Okay. I'm just gonna do a quick test. Can you want to ask them if they can hear online? We'll just make sure they can hear.
Absolutely. Can you hear us online?
If you can hear online, somebody just go in the chat and let us know you can hear okay?
Got a thumbs up, four thumbs up.
Okay.
Well, in that case, let us go ahead and get started. Good evening, everybody. I'm Linda Taylor. I'm the Director of Special Education for Paradise Valley Schools, and I'm excited to see all of you here tonight because the presentation is wonderful. It's valuable information for your child and your future. So I'm very excited to introduce everybody. But first, I'd like to do a housekeeping details. If you need the restrooms, do that exit, and on your right, do that exit and straight back. There's also water fountains out there. We have refreshments over here. So again, please help yourself. I'd like to also thank our help tonight. We've got some of our United Parent Council members. We've got Jessica Green. We've got Jessica Wani there supporting us with technology, and the lovely Deb Kozak, who helped bring this together tonight. So thank them, please, as well. And of course, Louis, the hostess with the mostest, who met you at the door.
Okay, yes, I am Deb Kozak. I am the United Parent Council Special Education Committee Chairperson. And actually, I realize this is probably my last seminar because I'm graduating.
No.
United Parent Council, or UPC, is just a volunteer group of parents in PBUSD that we come together. We have monthly meetings, kind of support the families, support, the district, and just make things better for everyone. And that's our hope. We, speak up on committees, interview committees, and also lucky enough in being a special ed chair, I get to work with this lovely lady and put on seminars to kind of help support our parents. So this one tonight, and here we have Emily Kile, and she's going to speak with us on guardianships, Social Security, able accounts, special needs trusts. So if your child, I know they're always our babies, turning 18 or getting close to it, it's a crucial thing for some of us. I personally I'd say 99% STEM because I got to get that last little component. We've had Emily come speak years ago, and I've heard her speak over the years. She's empowering to kind of educate you how to do this with the verbiage that you'll see, because some of it's kind of harsh. Yeah. I actually had her help us because I was overwhelmed, and very grateful I did, because it's a process. It's a very emotional process too. Gotta admit, I got in a bit of a fun. So I'm an open book. If you have any questions for me also, but take notes. We're going to have this recorded. We'll post it to our UPC YouTube account because you will need to go back and look at it. But Emily's also here to kind of help pave the way. So excellent.
Well, thank you for having me. Thank you. Thank you for being here.
I thought we were going to get on a roll when I did the first one, and I thought we'll just do this every single year, and then the pandemic sort of stopped everything. So thank you all for coming this evening. I know it's always hard to find time in your day. There's a lot going on, and I never know whether 6 o'clock is a good time, or you're trying to get everybody fed, you're all at work or taking care of your kids during the day, or whatever was going on. So I really appreciate that you're here. It's really nice for me to see humans and get your reaction and answer your questions, rather than me sitting in the office and staring at myself, which I do all the time. I do programs around the country talking about special needs planning. So truly, I appreciate that you're here, and I hope that I can answer your questions. In the packets that I provided is the PowerPoint that we're going to hopefully go through this evening. There's a lot in there, so I'll do my best to get through it. I just tried to sort of section it off by each of the categories that we're going to talk about. Then we have a couple of handouts that we always provide to our clients about able accounts and how you apply for SSI, some of the documents that the court will require to do the guardianship, and then a couple of brochures that have information about estate planning and guardianship in general. So if you have questions, raise your hand. I am a lawyer, so I have to do a disclosure. I have been practicing since 1993, so almost 30 years, or over 30 years, 2024, I guess. And I've had my own practice for about 20 of those 30 years. We're in Scottsdale in the McCormick Ranch area. And so I will do my best to answer your questions. As my slide says, remember, I'm not your lawyer. And ask questions that you think are sort of general for everybody, so we don't get into the weeds of your exact situation. But understand that sometimes the answer is much lengthier than the one that I'll give you, just depending on what's going on in your family and your situation and which topic it is. So a lot of things happen as your kiddo gets closer to age 18 or turns 18. You know, beforehand, you have this great structure that's there for you. You know what you're going to do. They're going to go to kindergarten. They're going to go to first grade. They're going to go through high school, and then the abyss. Plus, in the abyss, you have a whole bunch of legal changes, because regardless of who the person is, under the eyes of the law, they're considered to be an adult when they turn 18, regardless of what is going on with them. Doesn't matter if they're in a coma, or they have autism or Down syndrome, or they're just an obnoxious 18-year-old. They're still an adult in the eyes of the law. But we have some things that we want to think about for kiddos who are going to have some additional needs going forward. So that's what we're going to talk about. So we're going to talk about guardianship. I have one slide on supported decision-making, because I thought if anybody had a question, I might as well just answer it while we're here. And then a little bit about the basics of benefits, special needs trusts, and able accounts. So again, it's a lot. I've spent a whole day doing any one of these as a presentation. So we're going to have a bit of an overview, but I hope that I can cover the topics enough so you know what to think about as you're getting closer. So you say to yourself, she said she's going to talk about guardianship, and the first slide is conservatorship, which isn't even on the agenda. So the reason that I do that is because people get confused and think about conservatorship and guardianship as if they're one thing. And in some states, our guardianship, which is making decisions over health, housing, and education, is called a conservatorship of the person in another state. So if you come from a different state, or you have family in a different state, and they're going to say, I don't know what this guardianship garbage is that the attorney talked about, it's a conservatorship. It is not a conservatorship in Arizona. Conservatorship is about the money. It's not about the person. The other thing is, if you go on the self-service website for the court, you might just think to yourself, well, there's this thing that's conservatorship, so I'm just going to do both of them, because I don't want to not, if I need it, I want to make sure I've done it already. But you don't need it unless the person has money of their own in their own name that's more than $10,000 that you're not on the account. It's not just their monthly Social Security coming in, not in an able account or a trust. Like literally your person has money. That's pretty rare at this stage. Sometimes somebody got injured, and so we have personal injury award money or wrongful death funds. And then we have to go to court and get a conservator set up so they can manage the money for that person who otherwise can't manage it. But if you have a typical kid who doesn't have any money, doesn't own any real estate, you're happy they made it through school, you don't need a conservatorship. There's no assets to conserve for that person. And if they're getting Social Security benefits, or they will in the future, you don't need to be a conservator, because you'll be appointed as something called the representative payee, and that person reports to Social Security. And so again, you don't need to report to the court on a conservatorship. I just wanted you to understand what the difference is and what the concepts are, so the words make sense. So as I said, guardianship is the process of making life decisions for somebody who otherwise can't make them on their own. It is definitely taking some of their own personal choices away, because you stay in the role of as a parent would have to a minor child. So all the things that you've been able to make decisions about for the first 17 years and 364 days, might change when they turn to be 18. But if you're the guardian, you continue to have all of those same rights and responsibilities that you had before. So that's what the guardianship is. It's over making personal health, housing, and education decisions. There will always be a court hearing. They are all virtual. So it's on a device or a platform called Court Connect, which is a Microsoft Teams-based product, but it's different than Teams. So, you know, when you get a Teams, you get a link and a password like you do for Zoom. For this, each courtroom has its own specific link that you go to that's for that courtroom. And so it will come out in the notice of hearing to tell you how you get to that. If you don't have a device where you can be seen, then there's also a phone number to call in. You can go to the court, but they're not expecting you to be in court. The notice of hearing specifically gives you the virtual information along with the phone number. There are some ongoing responsibilities, and there'll be some new people in your life when you apply for guardianship. One of the ongoing responsibilities is that there's an annual report that's due each and every year, along with a health professionals report. In the packet, I've given you the court form of the health professionals report. We like to use that for the initial hearing, but thereafter, every single year, all the court wants to see is that your person saw a medical professional. It can be a progress note, can be anything as long as it's on the letterhead of that office. So that's going to be an ongoing responsibility every single year once you're appointed as guardian until you're not the guardian anymore. You always have to take into account the best interests of the person that you're going to be the guardian for and their goals and wishes. You don't have to do what they want. You don't have to agree with it, but you have to consider it before you make a decision. So it isn't just you deciding what you would want. It's how do I meet their needs, but still keep that person safe and make appropriate decisions for them. So hopefully that sort of makes sense. So who needs a guardian? So Deb talked about some of the terminology feels a little like,
It's a knife in the heart sometimes.
absolutely,
Yeah.
absolutely. And you worked so hard to help your kid or your loved one launch as much as they can. And then when it comes time for guardianship, there are lots of words that don't feel kind. So the person has to be deemed incapacitated. That's what the court is deciding. Is this an incapacitated person? But to bring it down to real life, is it somebody who is not going to be able to make their own health, housing, and education decisions without your help? Beyond, again, what a typical 18-year-old would be able to do or not be able to do. So oftentimes when I do educational programs, parents say, well, how do I know if I should file for guardianship? Well, I don't know. I'm just an attorney and I've never met your loved one before. So usually the school system is telling you they're going to need some help going on. The doctor, the nurse practitioner is telling you, I think that we've got some issues here and they're still going to need some help. And we need that medical report. So that medical report is the best evidence for the court, which is why it's required to help the court understand if this is a person who's incapacitated to the point that in fact they need a guardian, somebody to help make those decisions. Guardianships are called permanent guardianships, but nothing is permanent. Just like we do irrevocable trusts, and yet we can amend them. So you can terminate a guardianship later if the person is no longer incapacitated. You can terminate a guardianship because they've grown up and they've matured and they're able to make their own choices at this point. You can resign as the trustee. You have to do it through the court system, and that does not terminate the guardianship because the guardianship is over that person, not over you. And only the court can terminate the guardianship. So your kid might be really angry with you and say, I hate you and you are not my guardian, but you are still their guardian until the court gives you an order that says you are not the guardian any longer, or that the guardianship's been terminated. 1 second, let me just do one other point. You can file for guardianship, the earliest you can file, unless you're in juvenile court, because the kid doesn't have file, unless you're in jail, have disappeared, whatever it may be, and so you need to step into those shoes earlier. When they're 17 and a half years old, we can file in the probate division of the Superior Court. And then it becomes effective on their 18th birthday. But you can't file when they're 17. You can't file when they're 12, again, unless you're in juvenile, because you're not the parent and we need a person in that capacity to help them. But you can file anytime after 17 and a half. Usually I say that and I get a panic look of, I missed it. Now I'm totally out of luck. No, no, no. We do guardianships for people 17 years and 6 months old to 150. Like, it's the same rules. It's just that the earliest you can file is 17 and a half. The reason being that the court recognized that we don't want to wait till your kiddo turns 18, then wait for a hearing. And now we had maybe 8 weeks, 2 months or 3 months when we had no decision maker for them because they're over 18, the doctor won't talk to you anymore, and you couldn't file. So that's why we have that nice gap of time to give you the opportunity to file. We have emergency guardianships. Your procrastination is not an emergency for the court unless your kiddo has an emergency. Like, I have to make a decision, the doctor won't listen to me, they need this surgery or whatever it is that's going on. But I forgot and lost track of time because I had 8,000 other things I was thinking of. And now it's a month before their birthday is not an emergency for the court typically. Sir, you had a question?
Just a quick one on the health professionals report. Is that the only documentation the court would want, or would other supplemental things be acceptable, like IEPs, things from early development?
So the question is the health professionals report the only information or document other than all the pleadings we're going to go through that needs to be filed? They don't want to see the IEPs. They don't want to know like what happened when they were 3 months old. The doctor's report also has to be no older than 6 months. They want to know that they were seen recently, 6 months before the filing, not 3 years ago, even if the condition is not going to change at all, right? My niece has Down syndrome. She doesn't outgrow Down syndrome, but a report from when she was born is not going to work for the court for the guardianship. So sometimes we have additional specialists who provide reports, a neuropsychologist, whoever that might be, that's giving the court extra information. Sometimes, honestly, the primary care doctor report is not great. They don't want to say anything about voting or driving privileges. They don't feel like they should have the opinion on whether they, in fact, could live independently. So some more complicated cases, we will see the testing that was done by the neuropsychologist or psychiatrist. So more detailed reports. It's just that the court's form is something they're super familiar with. And it's really easy for the doctor. It's a check the box, fill in the blanks. So that's why I've given it to you. That's why the court has it. But they definitely don't want to see the whole history, which Social Security probably will. But the court does not want to see that.
Yeah, Social Security asks.
Yeah, Social Security asks for
APs,
everything.
net
When were they
reports.
diagnosed? Who are they diagnosed by? What medications are they on? Who are all the doctors they've ever seen since the day they came out? You know, everything you have. And you want to throw that all at them because unless it's super clear cut, we don't want them to say no. We want them to see, no, this is a long history. This person is not going to be able to be gainfully employed and have a job, which is different than the guardianship, which is, can they make their own health, housing, and education decisions now at the time of the hearing? So what I first thought you were asking is, oh, I just have to hand in my little health professionals report and I'm off to the races. And the answer is no. There's a whole stack of paper, and the probate division is the most arcane division in all of Superior Court. Everything is still pen and paper, no electronic filings. Once you're in the case, you can look at what's been filed electronically, but you cannot file electronically like you can in all the other divisions. So there's a lot of paper, a lot of copies of paper, because the judge needs a copy, the clerk needs a copy, the court investigator needs a copy. So the court website has a self-service center, and it has instructions if you're gonna go on your own on this. If you go on your own, follow the instructions exactly. Don't say, that seems stupid, I'm not gonna make 3 copies, because what will happen is your case won't go forward. So the instructions matter. You have to follow them exactly the way they are. So I had said you're going to have some new friends if you file for guardianship. So we have court investigators, which are court staff. They're terrific. They're useful people. They will come to your home or do a FaceTime or a Zoom to see what's the kid's room, what does the house look like. More and more, they're going out in person now. They're going to ask you some questions. You know, what's your job? Do you have any felony record? Who are the other people who live here? What's going on? Why did you decide to do the guardianship? All those kinds of questions, and you will feel like it is very intrusive. They will do a report to the court, and I will tell you what you tell them will be in the report. So if you hate your spouse that you're divorced from, and you say that spouse is awful and they haven't paid child support and I'm really angry, in the report it will say, the mom reported that they have a very acrimonious divorce and he is not paying child support, which raises concerns for the court investigator. So you need to be truthful, but please just use your appropriate filter and understanding what you're saying is not just between you and the nice person who's doing your court investigator report. You're there to provide facts, to show the court the person needs a guardian, you're taking it seriously, they have a safe place to live, you understand what their needs are. Make sense? After your initial hearing, you'll probably never hear from the court investigator again. They'll submit their report, and unless there's later a report to the Adult Protective Services of exploitation, abuse, or neglect, you're never going to see the court investigator for the rest of your life. I think we have 5 for all of Maricopa County. They're busy doing new cases and investigating terrible abuse situations. So you should never see that person again, but they can make a surprise visit if they feel like it. There's also going to be court-appointed counsel. We don't get to pick them. I don't get to choose. In the olden days, when I first started, I could say, oh, well, I want so-and-so on that case. They'd be like, okay, but they realized that maybe that was not from a court standpoint, the best approach, that you would just have your friendly person who maybe wouldn't give the court information that they otherwise would get, right? So now when we file, they just go through a process, and there's a list of attorneys who are on the list to be court-appointed counsel. And so if your kid has no money, which is almost all the time, they get paid like $323 by the county. You're not going to get billed. They've chosen that that's what they're going to do, and they do lots of other cases that they get paid on. They're going to show up at the hearing, at the virtual hearing. Sometimes they're easy to work with, and sometimes they're less easy to work with. They will want to meet with your kiddo by themselves, because they want to hear from your kiddo that you're not scared to be there, you're okay, they're okay with you being the guardian. Your kiddo has a right to object, even if it seems absurd to you. Even if we have somebody who has advanced dementia and thinks that what they really want to do is go to the moon because they're an astronaut and they want to object, their court-appointed counsel will object at the hearing. That is their advocate. That it's not somebody who is just looking out for your kid's best interest. So we always tell parents, tell your kid, this is what's going to happen. So you can do your best to answer their questions and allay their fears if there's somebody that if the child can understand what you're talking about. Because if they object, we're going to get to the hearing. There's going to be an objection. If we can't get over that objection, it's going to get set for an actual evidentiary hearing, where the doctor's going to have to testify, maybe the school personnel, all the people who can say, no, this is really a person who needs some help. So just be prepared. It's not just to check the box by the court-appointed counsel person. Also, at the end of that hearing, unless your person needs inpatient psychiatric treatment in the future, you're never gonna see court-appointed counsel again either. They're one and done. They're there to advocate and then they're out. For some of us, that is a happy day. Yes.
There's a question online. What if during this process with the court appointed attorney, your child is nonverbal? How would that be handled?
Yes, so they're still gonna want to do their best to meet with the child by themselves. The question, I think that they can probably hear you perfectly fine because you're closest to the mic there. So the question was, if they're nonverbal, what happens then? The court-appointed counsel is still gonna want to meet with your person. The court investigator is still gonna want to see them. If they have an assistive device, then you should have it available at the time of that interview so that they can interact as best they can with that device. But if they're nonverbal, they're either gonna get, no information back or nods of the head or whatever it might be, but there's still an obligation for court-appointed counsel to see the person as there is for the court investigator. Mandatory by the court rules. Yes.
Para pedir la tutela es necesario tener, es necesario tener un abogado o uno como padre lo puede hacer nada más.
To ask for a guardianship, do we need to have a lawyer or we can do it on our own?
Yeah, so great question. Do you need a lawyer or can you do it on your own? And the answer is you can totally do it on your own. The court site has a self-service center. It's a question always of time, money, and energy. So depending on where you are on that continuum, whether you want help and you don't want to have to deal with that, or you have the time to go through it. And as I said earlier, if you're doing it on your own, please follow the instructions exactly the way they are on the court website. There's no cutting corners. You can't do it faster. As I said, the court hearing is going to be virtual. Please be in a quiet location. Do not be out on the corner, at the street with the cars going by and the sirens. It's a court hearing, even though we're virtual. Treat it like a court hearing. Don't get on and go, hi, I'm here. No, we stay quiet until the court asks us to speak. And the court will go through its, raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth. They're going to ask questions. Be prepared. They're usually fairly short hearings, 10 minutes, as long as you don't have issues. But sometimes we have issues, so we need a little bit more time. Sometimes we have to take a break and say, we're going to come back. We didn't expect this, and have a little caucus and then come back to the hearing again. But also, I'm so embarrassed to say I had a hearing once and the gentleman did not wear a shirt. I did not know that I had to say, please wear clothing when you're in front of the court, So, you want to look like somebody who is making responsible decisions for your child. So think about that when you're in front of the camera. Yes, ma'am.
Like with beneficiaries, do you feel a primary guardian and a secondary guardian in the event that something should happen to the primary? You don't have to go through it again.
I love that question. So the question is, can you have kind of a backup guardian if the bad thing happens to you as the guardian? The answer is that we don't have backup guardians through the court system. You can have a co-guardian, can be you and your spouse and your other child who's an adult, you and your sister, whoever you want. You can have more than one person serve as guardian. But if you're the guardian, you're the guardian. You have all the same rights and responsibilities. We can set it up so each guardian can act independently. So you don't all have to be at every doctor's appointment, every school appointment, be with, both of you together all the time. So that, for example, mom and dad don't have to be at the doctor's appointment. Mom's at the doctor's appointment. She can say, yes, this is the course of treatment we want and go get the medication. You can set it up so you both have to be there, but we never think that's a great plan. You can have a backup guardian or a nomination of successor guardian in your will, or you can do a separate nomination of guardian document that's witnessed and notarized that says, if the bad thing happens to me and my kid, Joe Smith, needs a guardian, I nominate and appoint this whole list of people to be that person. And if the bad thing happens to you, they're going to take that form to the clerk's office along with a bunch of other papers, get appointed, and then go through this whole process. Notice of hearing, have a hearing, do your training, get a court investigator, have a court-appointed attorney, go through all of that, but then there's no gap in time. So we had the opportunity to nominate, we nominated, the court appointed, and now we're gonna go and do our actual hearing that we have to go through. There's an affidavit to sign that's, you know, that you're not a felon, that you're an okay person, you're not in the elder abuse registry, all of those sorts of things. Yes, ma'am.
¿Cuántas personas pueden entrar a la tutela del niño? Por decirlo así, mamá, papá, hermano, ¿cuántos?
All those words for that?
Yeah.
So you can have more than one guardian. Typically, the court's not gonna wanna see more than 3 total. Oftentimes, we have 2 as the co-guardians, and then as the parents age, maybe they add on an adult child to take over at that point. They don't wanna see 5 or 6 guardians. It's too much. But 2 or 3, not a problem at all. Yes, ma'am. Are you talking like in a divorce or, okay, so the question is, how do you sort of decide if the parents are not married and aren't on the same page about what to do? It's terrible, right? Probate court is not family court. They don't want to hear about your fight in family court. And in fact, if you're divorced, you have to attach to the petition a copy of the custody and visitation order that you got in the family court division, so that the probate division understands what was the family court thinking. So if the other parent has lost their parental rights, for them to come in now and say, I want to be the guardian and I should be, when they haven't seen the kids for the last 5 years because they lost their parental rights, probate court is probably going to be like, that's a no. But if mom and dad have had, or dad and dad, or mom and dad, or whatever, have had equal rights to the kid, and they've both done what they can, and they both love and adore that child, just because you hate each other, the court may appoint co-guardians. The court may decide, you guys don't get along, I can't have you as co-guardians, we're going to appoint a third party to be the guardian, because you guys can't figure it out. Because this is about the best interest of the kid, and guardianship is not custody. I can be guardian over my niece Marissa, who lives in Boston. The Boston court would have jurisdiction over her, but I don't have to live with her to be her guardian. So when people are going to get divorced and they have special needs kids, and we have an opportunity to talk to the family law attorney, we say, can you please work this out first? Explain that when this kid gets close to 18, these are going to be decisions. While they're hammering out everything else, maybe we can think about what that looks like. Otherwise, it goes to litigation. You have a hearing and the court could say, you're going to be the guardian and you're not going to be the guardian. Now you have no say over what happens to your kid.
Just how the legal decision making for agents to sell for guardianship, still have like a split or a 7/3.
Yeah, so the question is it like legal decision making where you can split up the decision making? The answer is no. You're the guardian or you're not the guardian. You have decision making or you don't, or you both do. But there's no, you get it on Monday, Tuesday, Wednesday, and I get it Thursday, Friday, Saturday. None of that is going to happen. We have limited guardianships. I got to talk faster. We haven't even had a guardianship and it's already been almost 40 minutes. You can have limited guardianships. So the person can retain the right to vote. They can retain the right to drive. We have to have evidence that they are able to do that they have the capacity to do that for driving, that they can physically, mentally, emotionally, they're going to be able to get behind the wheel of a car. I've had kids who said, I have my right to drive now, so I want the car keys. Okay, well, you didn't get a driver's license from the probate judge. All you got was it not suspended. They still have to go through the process with the DMV. My recommendation, if you want your kiddo to be able to keep their license, is that you go to one of the schools, Driving to Independence or whichever one, and you get a report that says that they've passed or that they're progressing towards a license. Because the judge is worried that is a lethal weapon out there on the roads, right? And so you're saying they don't have the capacity to figure out where they might live, but they can drive a car and be in a stressful situation, deciding on oncoming traffic, whether I'm taking a left or a right, is the light yellow, is it not? Am I too close to the car in front of me? Like all the things, the decisions you make like that when you drive. So having that report from an independent company is the best evidence that we can show the court that this makes sense. And just because their driving rights got suspended at that initial hearing, you can go back. So 2 years, 3 years, 5 years, they then go to one of the schools and it shows they can drive. You can go back to court and lift the suspension. They can take the test and get their driving rights. So those are limited guardianships. We talked about nominating a successor already. I have one slide on supported decision-making. People ask me, does this make any sense? If you're going to the autism convention in April, I'm spending 20 minutes, that's all they gave me, to talk about the difference between guardianship and supported decision-making. Supported decision-making does not give you any decision-making rights over your person. It's what we do every day, right? You have a decision to make. What should I make for dinner tonight? Oh, well, I'm not really in the mood for that. Okay, let's not have lasagna. Let's have fried chicken. It's the opportunity to turn to the people you trust and love and say, what should we do about that? Should I buy that car? Is this the right price for a house? Should I put my money in the stock market, or should I buy a CD with it? That's a supporter under supported decision-making. That's an agreement, an actual agreement that says, I'm going to use you when I have these decisions. But if I'm mad at you, I don't have to use you. And you don't have any rights to sign documents. You are not a substitute decision maker. You cannot speak for that person. None of that. You are just in the background trying to provide support. I think for some people who are very rule oriented and they want rules, a supported decision-making agreement might work because they're going to follow the rule of, I agreed I was going to ask mom about this before I did it. You cannot be you cannot be under guardianship and do a supported decision-making agreement. It is in the statute. If you have a guardian, that your agreement is terminated. So you have to have the capacity to sign an agreement. So you are not so incapacitated that you need a guardian. Well, if you have the capacity to sign an agreement, you should have a power of attorney. So I know that it took a lot to get it through the legislature. I'm just still trying to figure out where it works. But I want you to understand that having your kiddo sign one is not the same as having a guardianship. It does not give you the right to make choices for them. Yes.
Can you be a conservator and then still have this type of agreement, a supported decision?
If they've been deemed incapacitated by the court, the answer is no. The level of incapacity is different for guardians and conservators. So it might be possible to have that. Again, if they have capacity, they should be doing normal estate planning like everybody should. Just my opinion. Okay, we're going to talk about special needs trusts next. One of the most confusing things to people about what is it? Why do I need one? What if I don't want to have one? What's the impact? What's the benefit? So the purpose of the special needs trust is that money is going to go to a person on basically all tax or SSI benefits, supplemental security income, and there's a $2,000 asset limit. So they can't have any money. So the place to put it is a special needs trust because it's special and it gets special treatment where basically the person who's the beneficiary is never the trustee. They're never the one who has direct access to the money. They don't have a right to just get money, and they can't amend the trust, they can't terminate the trust, and they don't get to make decisions over the money. Everything is up to the trustee. So that might be a parent, a bank, a fiduciary, whoever, but they're the ones who get to make all those choices. So we have two kinds of special needs trusts. I don't know in the English language why it was that we couldn't come up with words that are different. Like, why is it Medicare and Medicaid? Seriously? It's confusing for people, and I don't know why they have to sound so much alike. So in our vernacular as lawyers, we have first-party special needs trusts and third-party special needs trusts. You're all like, what the heck is she talking about? So first-party special needs trusts are where it's the incapacitated person's money. So the most common way that we get this is where somebody left money outright. I die, I leave it to Marissa in my will. Then that might need a first-party special needs trust because it's Marissa's money, right? God forbid Marissa was in an accident and she gets money from a personal injury award. That's Marissa's money. That would go in a first-party special needs trust. So that's why my example, so Wilma ends up with $500,000. Grandma didn't direct it to a trust. She just said Wilma gets the money. So that's a problem. She's going to lose her SSI, lose her DDD services, lose her at Maltex, right? Yay, she got $500,000. Now she's got to not only pay for all those services, but she's not going to be able to access services that you need to be in the DDD program to get. No amount of money gets you the stuff that DDD provides through DDD if you're not in it. It's the way it works. The first party special needs trusts are a nightmare. And every time I do a presentation, somebody says, I don't ever want to have to do that. How do I avoid it? Well, nobody wants to do that, right? But we have to sometimes because Wilma just got $500,000. Unless you're going to spend it down and have no money left, that doesn't seem like a great plan. So we can still save it. But a first party special needs trust has all kinds of additional bells and whistles. Altex has to approve the distributions in advance. You tell them for the whole year. It's not like every time you want to buy a pair of socks, you have to call Altex and say, can I buy socks today? But there's a form that has to be filled out. They have to be given time to review it and approve the distributions. And every year they're going to want 12 months worth of bank statements to see how you actually spent the money. We do these because we have to, not because we want to. Should you set one up tomorrow? Absolutely not. We only do them when we have to. If the beneficiary is not competent, does not have capacity, we also have to go to court because although a parent, grandparent, the court or a guardian can establish the trust, you don't have the right to appoint yourself as trustee or direct anybody's money into it. I can't say, oh, grandma left you $500,000, Marissa. I'm going to open a bank account in the name of the trust and take your money and put it there. I don't have any authority over that money. So I'll need a court order on top of everything else. Yes, sir.
So proactively, if you have relatives,
Yes.
you'd be like, don't leave them money.
Yes.
Got it. Great. Thank you.
So proactively, what do? So we have third-party special needs trusts. Third-party special needs trusts are part of your estate plan over which you have 100% control. You can pick who the trustee is. You can say what happens to the money after Marissa passes away. In the first-party trust, Altex gets that money when Marissa dies, up to the amount it paid for her care. In a third party, your estate plan, you decide where it goes. I can say I created a trust for Marissa. When she passes away, if there's money left, it goes to her siblings. I can say it goes to charity. I can say it goes to you. It's up to me. I drafted the trust. I get to decide all of that. I have to tell Altex about it when it has money in it, but they don't get to decide how I spend the money because they're not the remainder beneficiary. So what you tell your relatives, who you like, hey, if you're going to leave money for my kiddo, I made this trust, this Marissa special needs trust. Make sure you direct the share for Marissa to the Marissa third-party special needs trust that I created. And what lots of people miss is if your parents' estate plan says that their money goes to their children when they die, and if a child is deceased, it goes to the child's descendants, the grandchildren. Well, what if I get hit by a bus and before my mom dies, And now it goes to my descendants, which includes Marissa, well, she's my niece, but includes my child who has special needs. Now she got $500,000 from grandma and she needs a first party special needs trust. So your loved one's estate plan should say, and if I'm deceased, any share for this child goes to this special needs trust over here. And everybody can direct it to one trust. You don't have to draft, each family member doesn't have to have their own trust. So in my family, I drafted the trust for Marissa's grandmother. Then I did the estate plan for my brother and sister-in-law, whose child she is, that says it goes to that trust. I don't have kids. So my trust with my husband says anything for Marissa goes to the same trust. So all the money is directed to one trust. You don't have to spend billions of dollars on a trust for each person if they're comfortable with that. So that's how you are proactive. So again, in my example here, it went to the third party trust. When it dies, it goes to her brother Fred. Clean, easy, simple, no court action, no state getting my money. You can have it as part of your will. You can have a standalone special needs trust, or you can have it as a sub-trust of your regular trust. My favorite is having its own trust for all the reasons I just told you. Easy to name as the life insurance beneficiary. Easy to name on my retirement account as the beneficiary. Easy for all those relatives to say it goes to this trust, not it goes to, the Emily Kile trust with a sub-trust for the Marissa trust here. So its own paper. I don't know if you've ever been to a bank and asked them to do anything other than open an account. It's really hard. So if you go in with a special needs trust that's this piece of paper, not can you look on page 30 of my trust because I want to set up a bank account. They're like, oh, duh, I see it's a document. It's got a name on it. Super easy to set up the account. As we talked about, you have to report trusts first and third when they have money to All-Tex and Social Security. Your estate planning attorney might not tell you that, but you have to, but only when it has money. So when you leave the lawyer's office and you set up a third-party special needs trust, it doesn't have a bank account. It doesn't own anything, right? It's only going to get money when you pass away. So you don't have to tell All-Tex about a trust that doesn't have anything. You might change your mind and decide you don't like that kid so much, right? And now you revoke the trust, or it never has any money. So you only have to tell them when it has money, because if you tell them too early, they are really confused. And they'll say, well, I need a copy of the bank statements and a title to everything that's titled to that trust. And you're like, I can't give you and prove a negative. There isn't anything. So I don't know how many of you have just recently gone through the fabulous fun of the renewal process for All-Tex and DDD, because we didn't have any from 2020 to last April. I thought it was the greatest thing ever. Yeah, the problem is now they go through a renewal for every single person on benefits. For somebody who has a first party special needs trust, they're asking for all the bank statements since the day the trust was created. Everything that happened in that trust. If you get a renewal letter, you get an envelope from Access, All-Tex, or Social Security, that is not your time to be a procrastinator. You must rip that envelope open and read what it says the minute that it hits your mailbox, because the deadlines are super short. And if you miss them, they will disenroll your person. And then you have to work to get them back on benefits. Don't ignore mail from Social Security, Access, All-Tex, the SNAP program, housing. You have to open those letters. When something happens, typically we have 10 days to respond. You miss the 10-day time period, bad news happens, okay? So open the letters, no procrastinating.
They are actually like calling and emailing too, because literally we just got that last week also.
Calling and
So
emailing.
they are more proactive, like they were just silent for years.
Yes.
And then, but they are just beyond the mail. So it's like, you have the reminders.
Yes, but I
Answer
will
the
tell you,
phone,
we have lots of
respond to email.
clients now
Yeah.
in the renewal phase who are, one second, who are saying, oh, you know what? I think I did get a letter. Let me go look back on the kitchen table. Oh, yeah, it was due March 1st. No wonder the bus isn't picking my kid up for daycare anymore, right? So open the letters, respond. Yes, sir.
Say. Same which referring to.
So the question is, when I say you have to report, am I only talking annually? When you have a special needs trust, that money went into, you must report it at the time, regardless of where you are in your renewal cycle. And if your person's on SSI, you have to tell Social Security, I funded a trust, here's a copy of my trust, here's the bank statement, here's an explanation of where the money came from. If more money gets added throughout the year to a third-party trust, we don't have to tell Altex about that. Typically, if more money gets added to a first-party trust, we had an inheritance, then we had a personal injury settlement, we absolutely tell Altex. Absolutely. So the question is more so with the first party than the third party? Yes, because the third party, Altex is not the beneficiary. On a first party, they are, and they get to approve every penny that comes out of that trust. So you only have to report your third parties once. You shouldn't have to report them. They might forget they got it and say it's not in my system, but you shouldn't have to report that more than once. But don't not tell them about it on your renewal form and pretend like it doesn't exist. Yes, ma'am.
You said that you report to all Altex and Social Security. What about the IRS?
So you would only be reporting to the IRS on taxes. So if the trust is earning income and it has to file a tax return, it files a tax return. If distributions are being made to the beneficiary and they're getting a K-1, then that gets reported to the IRS. That's no different than any person or any trust. Yes, thank you. Yeah, thank you for that question. We're going to talk about able accounts or stable accounts, as they're called. So an able account is a creature of federal and state law. So it's an opportunity, and this was the, at one point, this was the screenshot of the opening page. So it changes over time, but it sort of looks like that. If you just Google stable account or able account, you'll probably end up in West Virginia. So it's better if you can open one in Arizona. That's the website, az-able.com, totally free to open. You can't open it at a brick and mortar place, only online. There's no other way to open an able account. Lots of people told me that they were opening their able account in a different state because the other state didn't have a payback requirement to the state Medicaid program when the beneficiary died, and that was their way to avoid the money that might be saved in that account from going back to the state. However, Arizona will still collect the money because we didn't waive a state recovery from able accounts. So it doesn't matter where you opened it, they're still going to go after those funds when your beneficiary dies. Just like a first party special needs trust, except you can pay for funeral expenses and final administration expenses. On a first party special needs trust, when the beneficiary dies, you cannot take one penny out until the recovery agent says it's okay. In the able account, at least you can cover funeral costs at the end. So able accounts are a great place to put small amounts of money, and they're free. So if there was a small inheritance, $5,000, $10,000, you don't have to do a first party special needs trust. You can put it in an able account. You can put up to $18,000 a year. It's tied to the gift tax exclusion. So whatever it is next year, you can add that. But if you put in 18 and you spent 5, you can't put 5 more in that same calendar year. You can put 1,000 in a month, but the total amount deposited can't exceed 18,000 in a calendar year. And there's no catch-up provision like there are like for 529 plans where you can say, oops, I didn't have any money or I didn't start saving for college, and you have a catch-up provision. No, 18,000 a year. As long as it doesn't go over $100,000, their SSI is not impacted. It would be suspended if it goes over 100,000 balance in the account, They don't lose it. They're not disenrolled. It's just suspended. The person has to be deemed disabled prior to age 26. Next year, I think it goes to age 46. But you can't be somebody who was 30 in a car accident and got a brain injury, but was okay before that. They wouldn't get an ABLE account. But your developmentally disabled folks, these are great. I had a kid once who did a scratchers lottery. I've never won 1 penny in the lottery, but this nice young man did, and he got $12,000, of which he was excited, to which his mom called me in a panic. My kid has $12,000. The other panic phone call we get all the time is, I just remembered that when my kid was born, my parents bought US savings bonds and they're sitting in the safety deposit box. And I know they're worth more than $2,000. That's money to the kid. That could impact Altex, DDD, SSI benefits. Take care of it. Don't forget about that stuff. Because when you cash them in eventually, there's going to be tax reporting. And Social Security is going to go, huh? How is there tax reporting to this tax ID number of this kid who didn't have any money and was on SSI, right? So remember the stuff that's in the kid's name that might impact eligibility. So if they're working, they can put more money in an ABLE account if they're not able to participate in the retirement account at work. As I said, super good for small amounts, grows on a tax-free basis, comes out on a tax-free basis. It's in the tax code as a 529A plan. So just like if you have a 529 college savings plan, you know that that money's growing tax-free in there for the kid's education. And if it's used for education expenses, it comes out income tax-free. All the expenses, everything that comes out of this comes out income tax-free. And so you can use it for like anything for the kid. They're called qualified disability expenses, but I haven't met one that's not a qualified disability expense. Cell phone, clothes, games, apps, shoes, computer, television set, vacation, like all of that is for the benefit of the beneficiary. And if you do it wrong, the only thing that happens is the IRS could say, you took out $100 that was not used for a qualified disability expense. You owe income tax on the amount of that 100 that was income. All right, well, maybe that's going to be 15 cents. Like the penalty is kind of irrelevant. It's just not a lot of money because we don't have a lot of money in there. It's not like growing and earning interest and therefore we have income tax problems. Don't be scared of using it, and you'll get a debit card that you can use. So you go to Walmart to pick up supplies, you go to Target, you buy some clothes, you sign them up for soccer practice, whatever it is, you'll have a debit card that you can use. No cash out of the stable account, and getting checks is kind of a pain in the neck. So you want to use it for things that are easy to swipe at the store. Did I answer your question? Okay. I knew what it was going to be. So just kidding. For our divorced people, one ABLE account per kid. Mom and dad and grandma can't each set one up. They get one. Only the first one doesn't count against eligibility. Okay, only one per person, and it's 18,000 total. Not like your gift tax where you can give 18,000 for people who have a lot of money, do whatever they want all year long. No gift tax return for that. It's just 18,000. Yes, sir. Question is, does the guardian manage the ABLE account? The guardian could. The parent could manage the ABLE account. The incapacitated person can open their own ABLE account and manage it on their own. One of the selling features of the ABLE account was that it was an opportunity for folks who were disabled and on benefits to save money and learn how to be more fiscally responsible. So they can be their own. It doesn't necessarily have to be the guardian. When we do guardianships, we always put language in the letters and orders that says that the guardian can open and fund the ABLE account. You learn by things that didn't go great. So we had a guardianship that got transferred to Arizona. That language wasn't in the order. And they couldn't move the ABLE account out of the state and they wanted to move it to Arizona. And they weren't allowed to contribute any more money from the other states. So we said, we're always going to say guardians can manage ABLE accounts. We're always going to say that guardians can get paid rent if the person lives with them, because you have to, by statute, if you're going to collect rent from your kiddo, has to be in the guardianship order. Otherwise, it's considered self-serving if it wasn't in the order and approved. Yes.
Question online, going back to how you can use the ABLE funds. They want to know, can you use ABLE funds to pay for mom and dad to take a sign language class for child learning sign language?
That is a fascinating question. Can you use the money in the ABLE account for the parents to learn sign language so that they can interact with their child? My honest answer would be, I don't know why not. It's still for the benefit of the beneficiary to be able to communicate with the people around them. Again, worst case scenario, the IRS thinks it wasn't, which I've never heard of an ABLE account getting audited. It doesn't mean it can't happen, just haven't heard of it. Would be that there would be income tax due on the portion of the distribution that's attributable to income. That would be the worst case scenario in that instance. Yes, ma'am.
For the ABLE account, is it considered like gift money to put money in the account, or can I put it like out of each paycheck of mine into that as like a disbursement?
So the question is, can mom add money to the ABLE account on a regular basis from your own money, correct?
Yeah, like my paycheck, for example.
So you as parents can put money in. I could put money in your kid's ABLE account. Anybody can add money to the account. The question is always, do you want to? Remember, it can't grow to more than $100,000. And when the child dies, the state of Arizona gets the money back. So if you have funds, a third-party special needs trust is a better place to save money. And you use, I am pretty sure, 90% of your paycheck goes to take care of your kids. So you're already supporting them. So maybe you don't want to put money in the ABLE account. Maybe you want to put money in a savings account that's in your name and make the account payable on death to a third-party special needs trust. So if you needed that money because you're short 1 month on your mortgage payment, that you can still go in that savings account because it's yours. If you put it in the ABLE account, it is not your money anymore. So you can't use it to go buy your own clothes or pay your rent because it's not yours any longer. So just be conscientious. Sure. So you can have an ABLE account, a first-party special needs trust, a third-party special needs trust. You can have it all. Each one of those things has its own purpose, and they're all super important. And sometimes we need them, sometimes we don't. It just depends on the circumstances. So don't just run out and get a first-party special needs trust because you've heard the words, right? We talked about only when we need them do we do those. Third party is part of your estate plan. So you should, if you've got a kiddo with a disability and you're planning to not disinherit that person, it's really important to have a third-party special needs trust, and you can do it basically for free. So if you don't have money for somebody like myself to draft your trust, there is something called pooled special needs trust, like a swimming pool. And so they're nonprofits. All they do are manage money for incapacitated people. They have first-party trusts and third-party trusts. So if you want them to be the trustee, your will can say that Marissa's funds are going to go to the Plan of Arizona third-party special needs trust. I didn't have to draft anything except your will and direct it there, right? But your mom can't be the trustee of that trust. Your brother can't be the trustee of that trust. Your other child can't be the trustee of that trust. So the money is going to go to that charity in a sub-account for the benefit of your beneficiary, but nobody else is the trustee. Nobody else gets to pick who the trustee is. So there are options to get things taken care of so that we can take care of people. Yes, ma'am.
So I understand that the ABLE account has the debit card that can be used for many things. But I have a 20-year-old who I've taught to have a checking account and a debit card. So as a parent, I understand checking accounts, debit cards, and I teach my child how to do that. But then the able account, I guess I'm kind of like, what's the benefit again of the able account? Is it the tax-free part? And how does it compare to the checking account?
Yeah, so great question. Able checking account, what am I doing? So remember in the kids check, and then I will get back to it. Just remember you had your hand up. I didn't forget. So the checking account for the kid can't ever have more than a $2,000 balance. The able account can have 100,000. So they're often used when the Social Security is building up in the account and you're not spending it. That account, that checking account in your kiddo's name can't have more than 2,000 or they're losing all tax DDD and SSI. So oftentimes we money launder, we siphon the money off, right? And we put it over here, totally legal. That's what its purpose is. Or they're working a little bit. And so the money's going in their checking account and they're getting a little bit of SSI. And so now there's too much money again. So the money can go over to the able account and it can sit there and grow and nobody touch it for a while and you don't have to spend it. So it's a good place to hold every extra money. Who has extra money? Nobody. But it's the place for the extra money that's over and above the benefit level. Does that make sense?
Much needed, thank you.
Great. There was a woman back here who had a question.
So you can put SSI money into an able account?
You can. So you can put SSI money in an able account. You can put earnings in an able account. There's still income to the beneficiary. So if their earnings are too high and they're going to lose SSI, it doesn't matter that you put the excess in the able account. But yes, you can put the extra savings over there. So we usually say, open your rep payee account where the Social Security is being deposited, spend that money first. But if you're getting close to the $2,000 asset limit, move the extra money over to the able account. Yes. Yes, sir.
Say the kiddo has their own checking account, maybe they've done like search, project search program, they get job training, they get a paycheck, they're making their own money. So please careful, you get that. But would that only be if they're enrolled in the benefits, a certain dollar amount exceeds the benefits for that?
Yeah, so the question is basically, do they need an able account if they're not receiving any public assistance? The answer is definitely they don't need an able account, and you have to be deemed to be a disabled person prior to age 26 to have an able account. So if your kiddo is working and they're going to continue working and you're not applying for SSI and they're not on all tax or DDD services, well, they can have as much money as they have. It doesn't make any difference. The purpose is that we have a floor that's not very tall about how much money somebody can have if they're going to be on all tax DDD and SSI benefits. Do you have a question or stretching? Okay, perfect. Yes, sir.
Can able accounts make loans or purchase securities?
So the question is, can able accounts make loans or purchase securities? They cannot make loans. In the able, I think it's either Fidelity or Vanguard is the management for the money. You can hold it in cash, or they have like 4 different platforms: conservative, moderate, what, blah, 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 blah. So you can pick one of those and then it would be in securities. Yep, absolutely. Okay.
So
yes.
if the child is working, part-time, that child cannot earn more than $2,000?
If the child is on Altex, so they're getting DDD services through Altex, Altex pays for the services for DDD. Sometimes kids are approved for DDD, and you get to see your friendly support coordinator every few months, but no services are provided. So if they're on Altex benefits, or they're on SSI or both, their bank account total, they can have however many accounts, the total of all those assets can never exceed $2,000 by the end of the month. Correct. So that's That's the issue. And the number has never changed. You can talk about inflation all you want. The federal government has decided that $2,000 since the 1960s, when the program started, is too much money for somebody to have and still get help.
To have or to earn?
So, excellent question. We have income requirements and asset requirements. Assets is total money that's in the account. So you've got your income. Is it still in the account by the next month? Now it's an asset. If you spent it, you made $1,200 and you spent the money, it's not an asset in the next month because it got spent. Altex has an income limit of 2928, 2982. It's a combination of those four numbers. If you make over that, you have to do something called an income only trust or a Miller trust. So there's an income limit to what your total income can be in a month and still qualify for Altex. And for SSI, which we're going to talk about next, there's also an income limit because earned income decreases how much you can get in SSI. So if you make too much, you don't qualify because you can't get any money because you made too much money. So there's an income limit and an asset limit and a disability definition. Well, one more question before we do benefits because I have 15 minutes left. Was there a question over here? Just a stretch. Oh, look at that. Okay. So we have government assistance, some of which you just get because you earned it, so to speak, like Medicare, you paid in, you get out. Social Security, you paid in, well, the next generation pays in and you get their money. Like the older people get our money, right? So it's like that. You might have been a veteran, so you get some veterans benefits. But then we have benefits like we're talking about that are based on things like disability, income limits, asset limits. So I've been harping on SSI, supplemental security income, and Altex DDD services. But those are the two biggest ones that I see that people get, other than subsidized housing and potentially some food assistance through the SNAP program, the supplemental nutrition program. That's the link for the Altex manual in case anybody ever wants to look up anything in the manual. That's, like I said, that funds the DDD. Oh, 2829. I knew I had the right four numbers, just not what the order was going to be. So, and that's to offset care expenses, respite care, day programs, in-home care, assisted living, group homes, all that sort of stuff is what Altex covers. SSI is not Social Security disability. It is not Social Security retirement. It is its own thing. Supplemental security income, SSI. That's for somebody who has not worked. So to get Social Security disability, you have to have worked enough quarters, so you paid in, and then the bad thing happened to you. And it's like getting early Social Security retirement. The amount you get is sort of based on how much were you earning during your earning years before the bad thing happened to you. SSI is for my niece Marissa, who has Down syndrome. Does she have a job? Yeah, she earns a little bit of money. She's making credits towards disability and retirement benefits, but she doesn't make enough to live on. She can't be what they call gainfully employed, where she would work full time at a job, even at minimum wage with no assistance, right? So even if she were working, she had a job where she worked at the grocery store in the place where the restaurant is, or was before COVID shut it all down. But she had a supervisor with her all the time. That's an accommodation for somebody who's getting services, because somebody who doesn't need that isn't on SSI. They're earning their wages and nobody's looking over their shoulder all the time to keep an eye on them. So the maximum payment this year is a whopping $943. Again, all of your favorite people that live in Washington and fight over everything, regardless of which side of the aisle you're on, they think you can live on $943 to meet all of your food, all of your shelter, all of your discretionary spending. And remember, you can't have more than savings, more than $2,000 to get benefits. So that's the program. The best thing about getting SSI is you're automatically eligible for access health insurance for free. And we're gonna get to something called disabled adult child benefits, which is the golden goose at the end of the ticket here. When you are earning money, Social Security, the first $85 of earned income doesn't count against your 943. Every dollar after that is a deduction to your getting your SSI payment. If somebody gives you money of more than $20 as a gift, that's supposed to be reported to Social Security and is a dollar for dollar offset to the 943. So if I gave 40 bucks to Marissa, the first 20 doesn't count. Her SSI should be reduced to 923. Well, why in the heck would I give her cash and have the government give her less? She ends up at the same exact place. So for somebody on SSI, you want to pay for things directly and not have them have cash. You don't want to give them cash out of your wallet because that's a deduction. You don't want grandma to give money directly to somebody on SSI. And somebody who's working, as I said, could still get SSI, but you got to keep an eye on how much is the earned income so they don't lose the benefit. So they're going to stay on that benefit forever. Most of the time, you're not going to apply for this until the child is 18, not 17 and a half, not 17 and 364 days, 18 years old. Because otherwise, the income and assets of mom and dad count towards the $2,000 limit and the income limit. So most likely they will be denied. But once they turn 18, they're an adult. So now they can get the benefit, but you have to wait and call Social Security or file your application on their 18th birthday or anytime thereafter. And you want to do it before they turn 22 years old if you can. One of my handouts is how to apply. So you can go online and start the application process. Then eventually you'll get a notice as to when it is your phone interview is going to be and what documents they want you to have available, which is pretty much their entire medical history and entire employment history. And if you're the guardian, they're going to want either copies or certified copies of your letters of appointment to prove you can talk for your kiddo. Otherwise, they have to be on the phone with you during the interview. So these are sort of the common things that happen. You get a notice that they were denied for Social Security disability. Well, duh, we knew that. They didn't work. They're not eligible for SSDI, but they submit an application for both typically. You might end up with them saying, yes, you're approved. Certain conditions are automatic approvals. Marissa, Down syndrome, you get SSI. You might get a denial and have to appeal the decision. You might get a letter that says they have to go through vocational testing by the Social Security Administration to figure out whether they can work. DDD is about functional ability. Can they manage on their own? Guardianship is about, can they make decisions about health, housing, and education without help? Social Security is, can they work? Can they get a full-time job at minimum wage with no accommodations, no help from anybody, no extra breaks, no extra supervision? So they all have their own different medical criteria in order to get benefits. So some bizarre things that impact SSI: paying for food or shelter, although the food part goes away. The regs just got approved today. September 30th, making distributions and paying for someone's food won't impact SSI benefits anymore.
That
Think of that.
literally happened to us. That was like, why is it this amount? And it was because we
Pay for
was at
food.
home and we pay for food, and so it got deducted.
Food will go out September
Should've
30th.
waited a couple weeks. Just kidding.
So you got to watch out for the weird rules. I'm doing a whole program at the Academy of Special Needs Planners in Austin next month about what to do if you're getting divorced and you are going to get child support for your kid and they're on SSI. The general thing in 2 seconds is go to court, get a first party special needs trust, assign the child support to the first party trust, and that does not count as income against your kiddo, so their SSI will not be reduced. That is the bottom line in 2 seconds on what to do if you've got child support coming in. So I want to make sure my last few minutes. Disabled adult child benefits. I don't know why more people don't know about this like you do about SSI and other things. But if your kid was deemed disabled prior to age 22 and getting SSI benefits is your best evidence of disability, when you as a parent become disabled and start receiving Social Security, retire and start receiving Social Security, or die, your kid who was on SSI will convert to a disabled adult child benefit. If you become disabled or you retire and start collecting your Social Security, your kid will get 50% of your Social Security without impacting Altex or DDD services. Nothing in the government happens automatically, ever. When you apply for Social Security, you say to them, and I have a child who was disabled prior to age 22, I need for you to connect those two records and get them on disabled adult child benefits. They get 50% and it does not reduce your Social Security. It is true that there's a family maximum. So if your spouse didn't work and they're going to go on your record also, there may be some impact there, but the child is getting 50%. And when you die and the child now bumps up to 75% of your Social Security, and if the lower wage earner does any of those things first, and then the higher wage earner does any of those things second, they bump up to the higher wage earner. But you have to ask. Just like you had to ask to get on DDD, just like you have to ask to get services, just like you have to say, my support coordinator is not so great, can I have another one, or can I talk to the supervisor? You have to advocate and you have to ask. Don't expect it to just happen because of the friendly person at the other end of the phone. They will then, 2 years after they start that disability benefit, that disabled adult child benefit, because you retired, you became disabled, or you died, they will get Medicare for free forever, regardless of how old they are. So it's a really, really important benefit, and they will keep their access health insurance. So they will have Medicare and they will have access, so it will all stay free. So it's just amazing. And there are so many people who don't know about that benefit. And I just want to make sure that you do. That you are not people that I talked to who didn't know that this existed. There's also, and I don't remember the rule for sure which way it goes, but if you adopted the kid, they're still your kid and you can still get the benefit. So really important when you start your Social Security to ask questions to see whether you can get your kiddo on that benefit. So I got through all of my slides. You asked me fabulous questions, which is what makes it so fantastic for me in my selfish way. Is there a question online?
Yes, I'm sorry.
That's
I was so
okay.
engrossed in your
Yeah.
presentation. I'm 3 minutes late, but okay. So my son turns 18 and graduates high school next year, class of 2025. He's planning to go to college and already qualifies for some scholarships and financial aid should he apply for SSI.
If you have a kiddo who is gonna launch and get a job and go to higher education and they're gonna have a job, they probably are gonna get denied for SSI. It's free to apply. If you hire an attorney because it got denied, first of all, the attorney is gonna review all the records and they are not taking your case if they don't think they can win. But if they think they can win, they're gonna get a percentage of the back pay of Social Security from the time you applied to when it gets approved. You still have no out-of-pocket expenses, but they're not going to take the case if they review the records and don't think they're going to be successful. So anybody can apply for SSI. It's just a question of whether that person is going to be able to be gainfully employed or not as to the criteria. You might also have a kid who got approved for DDD and Altex and they turn 18 and they lose their benefits. because they are now, they don't meet the functional analysis test anymore, and they age out of the program. And a lot of kids are like, should keep benefits, but for whatever reason, Alltech says they don't meet the criteria. So again, thank you so much for staying. Thank you for having me. I so appreciate it. So thank you.
So our UPC website is pbupc.org. And so on there, there's a little tab link that takes it to the YouTube channel in like a day or two, right?
Yeah, I would say if we give a day. that
Yeah,
Our
we'll give a
community,
day.
it's not me, so that's why I don't want to commit to anything,
I
but I
know.
would say within a day. 24 hours.
But just keep an eye on that. That's where we have, like any seminars we do, any of our meetings and stuff, they're all there. So as time goes on, you might have to scroll a bit for it. Actually, your presentation from years ago is probably somewhere buried in there, but it's a video. This is a lot. We know, it's like, we were talking up here. I'm just kind of going through this and I'm still learning new stuff and I'm still getting overwhelmed and it's crazy. So pbupc.org, take the link and it'll take you to our YouTube channel. And this will be here in a day or two.
And we're going to get you back to the way to be, we're not able to grab one of Emily's packets.
Oh, yeah.
Over here, don't forget to grab them on your way out.
Yes. All right. Thank you all very much for coming to me. So, appreciate it. That's something for that she's speaking out. And she did, like, she actually, like, that's one of the mentioned. So it's just a key.
I didn't Google it. Let me see if I can get that one. If you put in the search.
And this is like,
Yeah. That's how I do it. I think it's PP.
No, but I was like, oh. So thank you for coming.
It's PVUPC. Just PVUPC. We're doing it. Oh.
Are you doing it right now?
But she's just, they're asking.
No, for.
Oh. We didn't get that.
Thank you for coming. Hi. Hi.